A probate guardianship is a court-ordered legal relationship that gives an adult, usually someone other than a parent, certain rights, powers, and duties regarding a minor child, the child's property, or both. A guardian of the person is given legal authority and responsibility over the care, custody, and control of a child, and is also responsible for the child's education, and unless the court limits the powers and duties of a guardian of the person holds the same rights as a custodial parent. The appointment of a guardian of the person completely suspends the parent's custodial rights and duties and transfers those rights to the guardian for as long as the guardianship lasts or until the child reaches 18 years of age. The appointment of a guardian does not, however, terminate parental rights without additional action by the guardian and the court. A guardian of the estate is responsible for managing and preserving money and other property that belongs to a child until the child becomes 18 years of age. Before filing for the appointment of a guardian, it may be useful to think about whether any alternatives to a guardianship are available, such as an informal child care agreement for a limited time, or a caregiver's authorization affidavit, which, when signed under penalty of perjury, allows a non-relative caregiver to enroll the child in school and consent to the child's school-related medical care. A relative caregiver may also have authority to consent to medical and dental care. A parent, and only a parent, can nominate a guardian of the person for a child if the other parent also nominates or consents in writing to the same guardian for that child, or at the time the petition for appointment is filed, the other parent is dead or lacks capacity to consent to the nomination. Even if the parent nominates a guardian, the court must still decide whether appointment of that person would be in the child's best interest. So who can petition for appointment of a probate guardian? A relative or other person, even the child of 12 years old or older, can file a petition asking the court to appoint a guardian. The person who files the petition doesn't need to be the same person as the one who asks to be appointed as guardian, but usually is. The court may appoint any adult, including a relative, friend of the family, or another interested person as a child's guardian of the person. The court may not appoint a parent unless the parent is terminally ill and is appointed as a co-guardian with a non-parent. Once a person has decided that a child needs a guardian appointed, the petition for appointment of guardian of the person or estate or both, along with all other required documents, must be filed with the clerk of the court. The petition must state that the appointment is necessary or convenient. Before the court can hold a hearing to decide the petition, the person who filed the petition must give notice of the hearing to the child if 12 years old or older, the parents, anyone else with legal custody, and anyone nominated to be the guardian by serving them personally, or if that's not possible, by first-class mail with an acknowledgement of receipt requested. Notice is not required if the court finds that the petitioner tried diligently and couldn't give notice to a person, or that notice would be against the interests of justice. If the child is an Indian child, notice must be mailed to any Indian custodian and the child's tribe as required by the Indian Welfare Act. The court will order an investigation before the hearing on the petition, and the investigator will contact the proposed guardian, the child, and anyone else who may know about the child's family and their needs. The investigator gives a report to the court and makes a recommendation on what decision the court should make. If appointed, a guardian of the person generally has the same rights to legal and physical custody of the child as a parent. A guardian is responsible for providing for food, clothing, shelter, education, and all the medical and dental needs of the child, as well as providing for the safety, protection, physical and emotional growth of the child. The child's parents can no longer make decisions for the child during a guardianship. The parents' rights are suspended, not terminated, while the guardianship remains in effect. The guardian has authority to decide whether the child can visit with anyone, including the parents. The guardian is subject to the regulation and control of the court in performing their duties and will be required to submit annual status reports to the court. A guardian may be removed by the court for specific reasons or when it is in the child's best interest. A guardianship will automatically end when the child reaches age 18 or if the child, parent, or guardian petitions the court for termination before the child reaches age 18. The court must find that the termination is in the child's best interest. If you are not represented by an attorney, the court's self-help center may provide assistance with filling out any forms you need to file.